To make sure that everyone's signed in for the meeting at the back entrance to the room. If you've not, please do so because it must be on the record. I am Bob Tanner. The other board member tonight is Scott Calhoun. I'd like to introduce the following members. We have Matthew Puz, Zoning and Development Officer. Julie Maggio, Assistant Zoning and Development Officer. Jeremy Toman, Board Reporter. Tamara Doxey, Court Reporter. I'm sorry, Jeremy Toman, Board Solicitor.
What happens when you miss one?
After the presentation by the appellant, the board will hear from those in question of the appeal, those in favor and those opposed. Any documents or evidence that's presented must be kept for a period of 60 days for our records. And after all the presentations are made, the board will recess. We'll then reconvene and make our decisions. The board has up to 45 days to render a decision, but they're usually made this evening. If you do not care to wait for the decision, you may call the zoning office in the morning after 8:30. I'd now ask that everyone please stand to be sworn in.
And if
Everyone who's going to be speaking tonight at all. Yep. If you have any idea of speaking, please stand to be sworn in. Okay. Do you swear to tell the truth, the whole truth, and nothing but the truth? Please answer, I do.
I do.
Thank you. Okay, for business tonight, we have 4 appeals. Appeal number 25-14, which was advertised, has been pulled back. So we have appeal number 25-15. And I'll actually announce several of these because it's the same party involved, and then we'll talk about them individually. So appeal number 25-15, Jason McGee for property located at 1219 Fillmore Avenue, seeking a use variance for limited lodging in the C1 Corridor Commercial District. And then also 2516, same party at 2728 West 13th Street. And then because we will, I'm sure, come up in discussion, even though we will render decisions separately. We have 2517-17, Jason McGee, for property at 1003 Grant Avenue, and that one is in the R1 single family. And lastly, appeal number 25-18, Jason McGee and Jennifer Perry for property located at 1103 Grant Avenue. And that one again is in R1. So if we could have Mr. McGee come up. And we'll talk about them individually, but I'm sure a lot of what we talk about will travel over to each thing.
As a procedural matter, before we get started, since we only have 2 board members, typically our full complement of board members is 3. Since we only have 2, if there is a tie vote, then it's a deemed denial of the application. So I just want to give you a heads up on that. So
If it's a tie vote, what?
it's a deemed denial of the application. So in terms of options, since we only have 2 board members here, I mean, if you wanted to get the full complement of the board, you could seek an extension. We could, and then the hearing just get postponed until the next meeting.
You would do that now? You would make a decision, if we said we wanted to postpone it, you would make the decision now?
If we said that we were gonna postpone, we would wait for I guess we would just move it to the next meeting and then have the 3rd board member here. But that's only if a split vote. So I just want to give you a heads up on that now before we started.
So what you're saying is, if it was 1-1.
Right, if one voted to approve it.
The whole thing.
What's that?
No, he's saying we would have to leave now
No.
and redo it, because if
No,
it's,
what he's saying, if you presented everything
and it's a
today,
tie,
and it's a tie, it's a deemed denial.
denial.
And then that's it. If you want to wait until there are 3
Right.
board members, we would postpone until the July meeting.
Right.
I don't.
And obviously, if both board members,
50, or you got, your call, sir.
I think we should go for
My
it.
next question is, should we hand out our topics now, or we do that?
You can hand them out now. If it's easier to hand all of them out at once, is fine. Thank you.
so are you okay proceeding then?
Yes.
Okay.
Yeah. So I'm Jennifer Perry. I'm Jason McGee's wife. So I'm a better speaker, so that's why I'm up here than he is.
Okay,
Hello, Matt, Julie, Jeremy, board. I know that we have the four separate, but my speech is going to be pretty much an inclusive speech that we can touch on the individuality of it throughout my presentation, and then at the end of the presentation, we can go over some of the details that I have in the packet. You'll see in your packet, there's an outline to kind of give you an idea of how I'm presenting our case or our defense or our plea for a variance. So first off, I would like to thank you for allowing us to voice our concerns on how the proposed property status change affects not only us, but our neighbors.
Ma'am, sorry. When you're reading, don't read fast, please.
Okay,
Thank you.
sure. Not only us, but our neighbors and surrounding properties. We have broken our points to consider into three main topics and supporting comments. Our first point is that we purchased the properties with the sole intention of providing vacation homes to the families visiting Erie. These properties were purchased prior to the new regulations and zoning codes. We have been renting 1219 Fillmore and 2728 West 13th successfully for the last 9 years. 1103 Grant and 1003 Grant for the last 3 years. These short-term rentals or your limited lodging, their platforms such as Airbnb, investigate potential properties and abide by all local laws. We were not notified, nor has Airbnb been made aware of any changes as per a phone conversation with Airbnb representatives. In addition, the residents of these neighborhoods were also not notified of the changes. There was not an opportunity for residents to oppose or support these changes. I included a due process clause that relates to property owners that we can discuss later on in the presentation. Not only are there restrictions for some homeowners, but there appears to be some favoritism to some of the property owners in the approved short-term housing areas. As per deed records, our houses are in the same subdivision listed on the deed as some of the approved areas. I've also included an equal protection clause that touches on the property uses that we can discuss. My question is, what negates permissible versus impermissible areas? And we do have a zoning map pictures that are included in our packet. The second point was, after receiving notification from Mill Creek Township of the zoning violation, we immediately began the process to be compliant. I contacted Belinda Fleming and Matthew Pez. I met with both of them. I've stayed in contact with them via email. I've been providing updates and completing the multiple and extensive list of requirements, which are also very costly. All the vacation homes meet the limited lodging requirements except for the floor plans and the land survey, which those will be completed soon. In addition to complying with the regulations, we have spoken to our neighbors and included signed letters, which you'll find in your packet, in support of our vacation homes that they live near. In all the years we've been providing housing, there's not been one complaint or a disturbance, noise disturbance reported since we started. In fact, there has been an outpour of positive feedback. This includes the cleanliness, safety, well-maintained exterior, etc. These factors, as well as the financial factor, were crucial to our decision to expand and continue providing our real estate journey in Erie. The third point is the multiple financial hardship this causes, as well as the future marketability of the property. When considering the purchases of 1003 Grant and 1103 Grant, the purchase price was based on location, house amenities, of which the major factor was the ability to rent it as a short term. Our 10-year financing is at 4.5%, was based on the short-term rental income. Since these incomes are significantly higher than long-term rental income, the combined Airbnb incomes for those two properties averaged $68,000 versus the projected long-term income of $43,000 a year due to the proposed change. Based on these numbers, monthly decrease of $2,000 per month, and factor in the taxes, insurance, et cetera, this makes our margins very tight. Also, the township's proposed change would give us a net annual loss on those properties, leaving no margin for deferred maintenance. To refinance these properties into a longer term would cost us roughly $2,500 plus the cost of appraisals, a higher interest rate of 6.97%. And lastly, as you already know, if we were to sell these two properties, buyers would be less likely to pay the premiums like we did, knowing these properties do not qualify for a short-term or Airbnb, thus projected rental income, as we stated earlier, which is a huge factor when evaluating rental properties. So in addition, with our letters of our neighbors, some of them were nervous getting tenants that don't care about the property or upkeep if they were a long-term or just a rental buyer that was not capable of taking care of it. Other responses that they were pleased with the property and how it's maintained and that they never hear any loud disturbances. As I mentioned, we've never had any complaints. We did provide their signatures and their addresses for you to contact them for a full picture of how the change affects us and our neighbors and the ripple effect that it has on the house market for the Peninsula Corridor. In conclusion, we ask that you consider not only the information presented today, but that we also are providing an invaluable resource for the Presque Isle Gateway Project and the Peninsula Corridor. We love Erie. We are a generational family of Erieites. My father-in-law had a business in Mill Creek for over 40 years. My husband has been a business owner since 1998. Our son graduated from McDowell, returned from the Marine Corps, and graduated from Mercyhurst with a degree in Intel. He currently works in the city of Erie and lives in Mill Creek with his wife and 2 children. I've been a registered nurse for the Erie community for 20 years. The guests we provide housing to come to Erie for many different reasons: weddings, vacations, funerals, birthdays. We house families that are displaced or have moved to Erie and are waiting for their new home. Also, housing for doctors and nurses who come to Erie to provide health care at our hospitals, nursing homes, for short contracts or their residencies. We would like to continue our hospitality journey and give Erie visitors the best experience. We feel not only that we provide a service for Erie, but also a valuable resource to the Erie tourism. I can take any questions about anything that you heard today.
So, Matt, I guess where I'm confused, it says Melinda Fleming. She's from Code Enforcement?
Correct. Code enforcement issues the limited lodging licenses, so they take care of the applications. The zoning office is responsible for determining if it's in the proper zoning district.
So it's not in the proper zoning district?
Correct. The properties in question are not in a zoning district that permits limited lodging.
So is there something in place that would, excuse me, I'm sorry. I guess I'm confused as far as they were contacted because limited lodging to get it up to code for limited lodging, but it's not in fact permitted there?
I was not present when Ms. Fleming and, oh my gosh, I'm sorry, Ms.
I
Perry.
can answer that.
Okay, yes.
So prior to the new regulation, which was what, Matt, 2022, October 2022, for the new regulations that were enacted for the short-term rentals, we had these businesses prior then. So what happened was Mill Creek's system identified through, I believe, AI program that there was properties that were working as a short-term that didn't fall into the mapped area that Mill Creek had decided were approved for. So there's approved areas and there's not approved areas. And we actually lie in between basically two approved areas, and like it's just a weird kind of map. But so what happened was once they identified that we were not in the zone and we were running a short-term through our platform is how they can identify us, or I don't know which other way they can. But we got a letter saying that we needed to discontinue our short-term, like a seize order, or we'd be fined $1,000 a day if we continued, and that we needed to make them a rental for longer than 30 days in order to be in compliance for those 4 properties.
And Mr. Tanner, I do want to clarify, the zoning ordinance was amended in May of 2022 that provided for the limited lodging areas in the township. There were supplemental regulations that were adopted that more specifically regulate the licensing of short-term rentals, which is how this process all started. The township did hire a company that goes through and surveys to see where they're operating so that we make sure people register and get licenses. It also identifies people that are operating in areas that aren't within our boundaries. And so 2 letters went out. Letters went out to the people that hadn't registered to say, hey, you need to register. And then other letters went out that said, hey, you can't have this in this district because it's not permitted. So there's the licensing thing, which is a separate issue, not related to this.
Okay.
Then there's the zoning side of it, which was adopted in May of 22.
So what she's saying is the houses that were in the area already just weren't registered. So now they sent a letter for them to be registered. So we have other properties that are in the zone that we got a letter for that we needed to register. So we are in the process of complying to that new law of registration and fulfilling all the financial obligations to make sure that they're safe for people to rent short-term. The other letter she's speaking of is the short terms that they identified that were outside of the zone. And those ones were to seize and not be permitted to rent short-term, only long-term. So we got 2 letters because we had some in the zone and some outside of the zone. And both of them have been purchased prior to May of 2022. So we were running these financial decisions were made in order for us to retire and make proper decisions to purchase these houses before there was anything on paper about short-term housing.
I guess I'm just confused why, if a property is not in the allowed area, doesn't that letter trump having people fix them up to?
And we're not asking them to, they're here seeking a variance to be able to operate the ones that are outside the limited lodging area.
Okay.
To operate them as that. My understanding, so that's what we're here for, is the variance is to operate the ones that are outside the limited lodging overlay district, to operate
Okay.
them as Airbnb, or short-term rentals.
To clarify then, you have more than 4,
Correct.
these are just the final 4 that are outside?
Yes,
Okay,
these
I
4 are
understand.
not within this designated zone.
Okay.
So you didn't receive letters from code enforcement for these 4 to get them up to?
No, that's not the, there was no letter sent out that the code changed. We got the letter that we were in violation after we had already started our business
Okay.
without any prior knowledge or notification that it had changed since we had bought them. So after the realization of getting the letter and we weren't in the zone, we're in a position now that after today's decision, we have to decide if we are going to sell these properties or if we're going to treat them as long-term, which, as I pointed out in my presentation, the financial aspect of it is devastating for our,
Understood. Just the way it was written, it made it seem like the township reached out to have you get these up to
No.
code, even though they're outside of the area, so I was just trying to.
No, those
You're
were-
talking about other units that
yeah,
are
like
within an
we-
allowed
yeah.
area.
Well, plus, we also are, if in the event we were approved, we were in the process of making sure that everything is up to code.
Okay.
So that we can then apply for the regulation, for the short-term regulation application, so then we can get started on that.
It's outside the zoning
Okay.
hearing.
Right.
Thing.
Okay, understood on that. So the next two items you have in here are, I'm just following down your table of contents, the deeds. I'm just following your table of contents, trying to follow your presentation. So number 2 and 3, you have 2 deeds attached. You wanted to bring
Yeah,
our
those are
attention
in
to?
your packet. The deeds are included so that you can see the purchase dates. So the 1, 2, 3, or the 2, 3, 4, 5 are just the copies of the deeds so that you can
Okay.
see the purchase date. The zoning maps are next so that you can see where we are, our houses, and where you can see there's approved zones right next to ours. Like I said, I don't know the understanding of how they pick the zones, but like one street over can be approved and my street's not. Or, across the street on 12th, one side is approved and our side is not. In reference to 1219 and 2728, those are not the R1, they are C1, I believe, or non-conforming, but that's on one deed because the property is connected and purchased together. We actually can't even rent that house long-term. We tried. And it's surrounded by 3 businesses. I mean, there's a repo lot next to it. However, it is a viable short-term because people come up for vacationing and it is in a good location near the peninsula. So they're less opposed to the environment, the exterior environment, than a long-term would. There's no grass, there's no backyard, it's not family-friendly. The owners lived there prior to our purchase. It was a German family that came over to the United States legally and lived there and created a business. And so they just lived in that house with that property. The garage that's attached to it had apartment, and that's how it goes. So running it long-term is really not viable.
Okay. So just so we're clear, you're talking about
1219
1219
Fillmore.
Fillmore and
27.
2728 West 13th
Yes, sir.
are on the same parcel.
Yes.
I just want to clarify, they're not on the same parcel. They have 2 separate tax ID numbers, but they are abutting one another.
They're on the same deed and their properties are connecting. The garage to the house is connected, a building is connected to the 1219. They're not separated. So the 1219 building is connected to the garage of 2728.
Sounds like that's the garage. She's talking like that, but it's connected to that. Whatever that means.
For taxing purposes, they are identified as 2 parcels.
But you're saying they can't be rented long-term because,
Well, it can be. We've tried. It's just we don't get, either we get poor tenants.
I thought you said they couldn't be because they were on the
We
same.
can't do it because it doesn't bring the income in. It doesn't,
Understood.
we have outstanding loans, and nobody wants to pay $1,200 a month for that house because it's in the middle of industrial.
I understood you saying
Yeah,
it like
sorry.
legally they couldn't because it's 2
No,
dwellings in
sorry,
the
sorry,
same.
sorry.
Okay,
No, we just can't because we can't viably afford it.
okay. So then number 8 in your packet is 1003 Grant Street.
And that's the map.
And then we have 1003 Grant Street, right?
1003 and 1103 Grants, yeah.
Yeah.
Yep.
What are the stars on your map that are labeled?
Those are the neighbors that we spoke to
Okay,
that are in support of us.
okay.
And where is the area that is zoned for limited lodging?
That one. Do you have that map, Jay? I don't see it in
So it would be, if you're looking at the Grant Streets,
map.
you see the map.
Oh, the
You
blue,
see
the blue.
crosshatch on the top, the orange crosshatch, that's a limited lodging.
And the
Up here?
blue,
Yes.
The orange.
Blue below that.
yeah,
Okay.
That's mixed use.
yeah.
Affordable.
And the 2728, you can see all the blue and orange all the way around our property. Like, this all blue is just all around it.
What number is that sheet?
This is the map for number, this is 6 and 7 map.
Oh, okay.
Matt, is that accurate? The blue designation, that's where limited lodging is a permitted use?
Attorney Toman?
See here.
I do have a map that is the limited lodging overlay district and where it's all permitted, so I was planning to introduce that.
Okay.
So if you want a copy now, I can do that.
Okay, yeah.
No need for me to answer?
What's that?
Do I need to answer? Or did Lydia already?
No, if Lydia's got it.
Okay.
She's got the map as well.
I have a bigger one and a blown up one too, but also,
Because the air conditioning doesn't work. The air conditioning doesn't work as well.
Eyes aren't that good.
Although Fillmore is.
I've marked this as Township Exhibit A, but
Okay.
I can give you this one that's blown up a little bit more, but it also has highlighted our houses so that you can see it on this one. Hers doesn't indicate which our houses are ours. Would you like it? So right here, the 2 yellow ones.
Get back. Okay.
That makes sense.
Moving forward to the next thing in your table of contents, the checklist.
That was in good faith that if we did get approved, that show you the multiple, and this is just 2 pages of the requirements to be compliant.
Okay,
To let you know that both houses, or all 4 houses are in compliance at this time, except for the survey and the floor plan, because those are quite expensive to get. So we're holding off on those 4 properties, because it's like $1,000 each for each one, to get a floor plan for each house that which we have, I think, 11 total, but the 4 here. So that was just in good faith that if we did, I wanted you to know that we were in compliance with the whole entire list that's required for that, and that we are willing to get the survey and the floor plans to continue to be compliant.
okay. And then number 11 is pretty straightforward, it's letters of support.
Yes, we did talk to our neighbors, and we did get their signatures and addresses to be contacted. We do have 2 neighbors that are present for support of us. Not
Okay.
sure who's here to oppose, but we do have 2 people that are in support of it, and the rest of them did sign saying that they've never had any issues. Like I said, the 9 years we've been doing it, and then the 3 years just at the grants, we have not had any complaints.
Okay.
What did you say about the opposed? Are there?
I said, I don't know if there's anybody here opposing. I don't know yet.
Aware of anybody?
I'm not aware of anybody in our neighborhood. I do frequently advocate for the short-term rentals on different platforms like the neighborhood, because people have a misconception. Obviously, only the negatives on the news, and they're worried about parties and whatnot, and lowering the value of their property, which it doesn't lower the value of their property. It actually increases it because it's an income-based property. So if you're selling it, if you can make income off of it, it increases the value, which why if we resell, we can't resell it for as much as we can if it's not going to be an income-based property.
Okay.
And so that would make the other properties in our neighbors more valuable if they were able to. But.
Go ahead.
That's it. Was that it? Just it?
Just what do you have next? Yeah.
Oh,
12, 13, 14?
those were, so 12, 13, and 14 was my desperation of finding evidence that to support the fact that for the overview taking clause, I just wanted to highlight the Fifth Amendment Constitution says, private property shall not be taken for public use without compensation. And then also the, let's see where it was, deprive a person of protective, let's see. You'll see I highlighted some of the things about it. Basically, it was saying to, even through zoning, by denying us the ability to make a profitable income investment on our property, that it's part of the amendment that says you can't do that. You can't take somebody's property without either compensation or if they're gonna lose property income from that. And then same with the due process, just the fact that we did not have the opportunity to oppose or agree to the variant or to the code changes. Usually, like everybody here got a letter that I was putting out a variance so that they can come and oppose. And I just was like, for due process, the procedural part of me being able to oppose or be in support, which I would be supportive, I didn't have that opportunity when the changes of the code went in. And the equal protection, the only part that kind of stretches it a little bit is, the standard of generally differentiating between permissible and impermissible, and that is there favoritism for the places that, for the areas that were approved for the areas. And are they inclusive or are they under-inclusive? Is there an inequality factor in those areas that were chosen? And that's just me trying to point out that whoever makes those decisions, I don't think the public had a wide open awareness, and that the economical viable use of our land and the grandfather clause in the zoning are all parts of my plea for approval. And the final thing that I had on the one page was just that the zoning in the United States is expected to cost hundreds, billions, trillion per year in lost economic output because of zoning restrictions. And as you know, obviously, I'm a very big fan of Mill Creek. I live there. I love Presque Isle Gateway ideas. I've looked it up. I think it's an awesome, we live right in that corridor. We want to be part of it. I think there's room enough for the hotels and for more short-term. I think the tourism for Erie is expanding. We're right next to the airport. Waldamere's expanding. I don't think restricting housing for people is the answer to expanding the tourism. So.
Okay. Yeah, I don't think I have any other questions at this time. Jeremy?
When you're applying for variances, there's certain criteria that you have to meet. And I believe that, at least included in our packet, and I'm assuming that you received the same information from township possibly, but it's also part of the zoning ordinance. And it gets into those requirements. So there's 5 requirements for a variance. Are you familiar with that?
No.
Okay. And so maybe what makes sense is just to kind of go through those real quick, and then you can kind of let me know what your understanding and what your take is on those. So the first requirement is that there has to be unique physical circumstances or conditions, and that's associated with the property, that create an unnecessary hardship for you to comply with the zoning ordinance. So is there anything, I guess, in any of these parcels that you can describe as being unique that, kind of, right now, my understanding is that there's single-family dwellings on each of these properties,
Well,
correct?
the Fillmore ones are non-conforming C1, but,
Right, so it's a non-conforming, but that would be a non-conforming use as a single-family residence in for those properties?
I mean, there's a single-family house there, but it's not listed as single-family, so I don't know, you tell me.
What's that?
I said there's a single-family house on that property, but it's not listed as a single-family property.
Right, yeah, because of the change in zone. Well, I guess in terms of the prior zoning, let's just, I guess, take a step back. Prior zoning, was the limited lodging permitted in any, I guess, on any of these properties, any of these 4 parcels?
The prior zoning for Fillmore and West 13th, those would have been located in the resort commercial, the RC district, which permitted cottages. But other than that, I don't have, there wasn't really any supplemental regulations at that time.
And that was for the Fillmore and the Western 13th Street?
Correct.
Properties? Okay. And then the Grant Avenue properties,
Those would have been in the R1 district.
those R1, you said?
Yes,
Okay.
correct.
But there's, I guess, with respect to Fillmore and 13th Street, if there was a prior use, the single-family dwelling, for, I guess, residential purposes, that would be a non-conforming use, so they would continue to be permitted to use that for a single-family dwelling?
Correct.
Okay. So.
Or
I
if
guess-
it wasn't being used as a single-family house prior to those regulations, what then?
Then that wouldn't be a non-conforming use. So you'd have to basically comply with the zoning ordinance. So if there was no prior legal non-conforming use, then you'd have to comply with the zoning ordinance.
Okay.
So getting back to the requirements of a variance, so I guess with respect to any of these parcels, is there any unique physical circumstances, conditions associated with the property that basically say you can't use it for any other purpose but the limited lodging?
That's part of your requirement for a variance, is that it has to not be able to
Yeah,
be
so.
existing in itself as any
It's
other,
well, no, it's just is there any physical conditions associated with the property that,
well, it
Quite
already exists. The physical condition already exists and complies to a certain use. So,
I think the question, so, I mean, I think if we split it out by parcel, maybe it'll
Right.
help her out a little bit, right? So, starting with 1219 Fillmore Avenue.
Yeah.
In order for us to grant a variance, we have strict criteria that are set forth, okay?
I'm sorry, repeat
There are
that?
criteria that are set forth in order for us to grant a variance.
Yes,
Okay?
yes,
So, when he talks about the unique physical circumstances or conditions, that sort of thing,
yes.
starting with 1219 Fillmore.
Yes.
Does it have unique, I'll read it.
Here, I'm going to give it to her.
Oh, perfect.
I also have a copy of them if you need them.
Okay.
So I don't know if it's easiest to
Well-
talk about 1A
Sure, sure.
and then talk about that for each property, or?
Sure, we can
yeah.
do that. I mean, my limited understanding of this, I guess, is before the regulation, it was used as, it was used as a garage and a rental. There was nothing preventing it from being that. Is there something preventing it from being anything else but what we have been using it for? I would say the surrounding environment prevents us from using it for any other purpose, because, like I said, we can include the 27, 28, I'm comfortable with grouping them as the surrounding areas make it difficult or hardship to be able to use it in a better circumstance than what we're currently using it as, yes. That's how
So can you describe that just a little bit?
So there's a repo lot right next door. There's a junkyard on the other side. And one of the businesses was damaged by the snowstorm and the roof collapsed. So part of the building is still standing and the other part is cleaned up, but it's a lot. It's just like a construction lot, but it's cleaned up. And so our properties sit right in the middle of those two, or of those three places. So that's how I would describe the inconvenience and difficulty and hardship of trying to get those two specifically to be anything but what they are.
If I may speak, if you were to drive by and look at the place, it's chain link fence with barbed wire on the top of it. So when you're in the 27, 28th Street house and you look out the kitchen window, you have barbed wire and chain link fence. You guys can see from the aerial pictures, it's just a repo. And then on the other side, you can see again from the aerial pictures that it's vehicles that run, vehicles that don't run. It's an industrial collective unit. And we've tried to rent it long-term, but by the time you get down to a point where somebody's gonna pay for a monthly rent, you're getting the bottom at the bottom. I have been through the 27, 28 house, and the last people we had in there, they destroyed it. It was destroyed. Now, I'm a painter, and I would happily repaint everything, but the destruction was on a global scale. In the 1219 lot, it's just one big parking lot, and then you have a nice finished apartment inside and an apartment upstairs. But again, you're in the middle of industrial. So to get a family in there, or somebody on the up and up to rent, nobody's gonna rent that. That's why Airbnb and short-term rentals fit for that property.
Mr. Tanner, if I may.
Go ahead.
In an effort to streamline for two of these properties, with respect to the 1219 Fillmore and the 2728 West 13th, this is similar to last month's hearing where you heard requests for Airbnb with respect to the industrial, the I-1 district. While it would be the township's position that they don't meet the necessary standards for a variance for the hardships perspective, to the extent the board is considering granting a variance, we wouldn't push back on that, provided that it be conditioned that they comply with the short-term rental ordinance requirements.
Okay.
But with respect to 1003 and 1103, we would not grant that kind of concession. We do feel that they don't meet the hardship requirements and there was no pre-existing non-conforming use, and I'm happy to get into that with Mr. Puz.
All right, so I think what makes the most sense is let's continue down through this for the first two. We'll do them in
Yeah.
groups of two because they have similarities.
Yes, absolutely. So we're on to the Grant Streets now then?
Well, no,
Oh,
You want to just,
Oh.
we're going to go through all
Oh,
of them.
those
for-
things for
yeah,
the- okay,
for
okay.
Fillmore.
okay.
so we kind of touched on A and B.
A and B, okay.
For Fillmore and 13th. C, the necessary hardship has not been created by the appellant. You concur with that?
Yes.
You didn't put in the junkyard next door, you didn't?
Right, yes, sir, yes, sir.
The variance, if authorized, will not alter the essential character of the neighborhood or district in which the property is located, nor substantially or permanently impair the appropriate use of development or adjacent property, nor be detrimental to public welfare.
Not at all. It would improve, actually, the neighborhood, and even if different businesses did take over those other ones, it would still comply to any ordinances that would need, and like I said before, we are complying to all of the code regulations too.
And it says that the variance, if authorized, will represent the minimum variance that will afford relief and represent the least modification possible of the regulation in issue.
Yes, sir, we could maintain that easily.
Yeah, so those ones we
Yes.
talked about. Now, delving further into 2517 and 2518 appeal numbers, so we're at 1003 grant and 1103 grant. Let's talk about the same
Sure.
thing. So are there any unique physical characteristics or conditions of those lots?
Not any physical characteristics, and as I stated before, understandably, obviously, you guys can decide if you don't want it in the R1, and that's your decision, but the defense I have, and my plea is that, one, we really did purchase these with a financial expectation by taking out loans, so not the physical circumstances, but the conditions of, not of the physical property, but of our financial conditions, that is going to be a very strainful thing because we based it on that. But also, we did it before the regulations were enacted, and I'm not familiar with law. I just did some Googling to try to defend myself today. But with that being said, that's why I brought up some of the Fifth Amendment and the 14th Amendment as far as that went, because also with the grandfather clause is because, like, if it was a business that was there prior to any regulation anywhere, I don't know how a court of law would handle that or how rezoning would manage. Would they give us a time limit? They give them a time limit to get rid of their business or whatnot? I don't know that. But no, there's not any physical circumstances, but there are conditions, and your conditions might be different than what my conditions mean. But with that being said, I think they're just as valid.
Okay.
I mean, the renovations that we put into these houses was astronomical to improve that neighborhood and to improve the repeat customers that we've had to come to be part of the economic boost of the township and of Erie. I just don't, I don't understand the restrictions for a homeowner when we're allowed to rent it, 30 days, but we're not allowed to rent it for 7. I understand the safety issue. I'm more than willing to be compliant with the safety issue. I think long-term has the same stipulations that a short-term should, but that's for another, date, I suppose, to discuss those items. I'm just here to plead for these 2 properties at this time. Obviously, we're not going to be purchasing any more properties that are out of the zone, but because we did this beforehand, I find it to be a very devastating financial hit. The conditions of which we are talking about are a financial, emotional, and a blood and sweat and soul.
Yeah, so unfortunately, one of the hardships cannot be financial. That is not a hardship, the way this is written, as far as what we're able to hear. I understand it is, but that's,
And I guess the definition of hardship should just be one definition and not divided into a physical or a financial. I think a hardship is a hardship. So
I mean, and
your
that-
definition of hardship is obviously different than than the definition in the
And I
book.
mean, we fully appreciate the financial hardship component of it, but when you look at the requirements for a variance, they're looking at the physical circumstances. Now, getting to your point about like grandfathering, the code does allow, and that's what we were getting into when we were talking about legal non-conforming uses. So as long as the use before the zoning change was legally permitted or permissible
Which
in
it
that
was.
zoning district, well, I think that's what the township is taking the position, and Lydia, correct me if I'm wrong, that it was not a permitted use in the R1 district before the zoning change.
Correct.
Do you have a code variance or enforcement or whatever stating that? Because I couldn't find it.
I have a
Prior.
copy of the code from 2011 that does not provide for short-term rentals or limited lodging in the R1
Why is it
district.
2011?
That was the last adopted version before we amended it in 2022. 2022 was the amendment that provided for
But it permitted long-term.
regular rentals of homes and apartments
I'll
was
take a
permitted,
copy of that.
but short-term was not permitted. And
we'll
that's,
let Lydia present that when it's her turn in just a
Yeah.
moment here.
But I just wanted to give
Yeah.
you some context to understand the grandfathering component. So if it was legal, if there was a use that was legally permissible, so for instance, if for some reason it was permissible in a different I guess, under the code in the R1 district at that time and you were using it, and then all of a sudden the new code comes in and it changes and it says it's, that's no longer permissible. If you were using it, under certain circumstances, then you would be allowed to continue to use it as a non-conforming use.
Sure.
But, yeah, so that's getting into that grandfathering. just so
Okay.
you-
Sure, I understand that. I'm not sure what, you said Lydia? Is that what you?
Yes.
I'm not sure what Lydia's going to present, but I'm sure it's probably something in the area of that you can't put like a hotel in that area.
Well,
And I'm
well,
assuming that
well-
that's short-term, but I believe that you have the authority to differentiate between a hotel, a motel, or a housing unit, which there is, by the way, there is apartments, down the way too, that, house people. I don't know if they are all long-term, but they do have little apartments in it, but.
Yeah, and we'll give her a chance to present
Right,
that.
but
and
I
you can
just
hear it
wanted
in
to say
full, and
before-
you'll
before
have a
she can
chance to
tell-
respond to what
Okay.
she says,
All right,
okay?
yeah, sure.
Such unnecessary hardship was not created by the appellant. As we know, that it was a decision, because you stated on your financial hardship here explanation that these could in fact be rented as single-family, but it would be not financially feasible.
Correct,
Is that fair?
correct.
Then we get to D. The variance, if authorized, will not alter the essential character of the neighborhood or district in which the property is located. I know you have stated that already. I don't
Yes, sir.
need you to again. I know there's
Yes,
people in
sir.
the audience that might state similar or otherwise, and we'll let everyone
Sure.
speak to that. If authorized, would represent the minimum variance that will afford relief and represent the least modification possible, would be the last thing. So if you read at the very top, it says, the board may grant a variance provided that all of these findings are made where relevant. So that's where we just need to hear from Lydia on her piece, and we'll continue. Is there anything else you'd like to say about these items on these two units?
Just a question of, with the variance, that to comply by all of them, there's no exception of reasonable expectation of being able to grant these, because I foresee in the future that the extension of the MU and the short-term limited lodging will be expanded. And I believe that it should be a fair topic to address. Maybe now is not the time, but I do want to consider that those things might extend into a wider perspective, because there is a supply and demand need that's coming to Erie, for housing and for the Presque Isle Gateway. You guys are doing big things. You spent a lot of money on getting those four, places where, Joe Roots was, and the Sandbar, and knocking down the Bel Air. I mean, there's big things coming. And I just think that we're limiting these short-term limited lodging areas without the thought of expanding to a bigger and better tourism for Erie. So I did want to keep that in consideration, because if there is any way to override, we're not meeting all these variances, I think this would be an example of why we should, is because of the expense that Mill Creek has spent on trying to increase that tourism, and we're part of it. We're trying to contribute to that part too, and I have a feeling it'll expand because there's going to be a big demand for it.
Okay.
And, unfortunately, we're just here today for this particular variance, and so that's, I guess what we're focusing on tonight.
Oh, yeah, I understand.
But yeah, I mean, and that's something that you can, whether it's the township, or even like seeking some type of amendment to the zoning ordinance, the zoning map, things like that. There's other, I guess, avenues to pursue something
So
like
perhaps
that.
I should have been informed of that part, because that would make sense to me, because I feel like, you're here because of the variances, I'm here to defend my property. So in part of that defense, I'm discussing those options. If there's another option for me to change the amendment of the regulations, then I would definitely take those proceedings to do so. I just don't have that, I didn't seek it out, but I didn't know there was an option to change the regulations instead of just asking for a variance. Plus, I didn't know about these, but that was my fault. I did research on everything else, but this.
Okay.
Thank you.
I think we covered everything now. Okay, I think we're okay with
Okay.
you for now, then.
Do I sit here and go back to my chair? or-
You can sit here in case she has any questions for you.
Okay.
Lydia's going to speak, and I see some of you in the audience raising your hand. You will be given time. Once this portion is done, you'll be given a time to state whatever you'd like.
Absolutely. Okay. As indicated, my name's Lydia Caparosa, and I am solicitor for the township. I will be taking some questions from Mr. Puz, but I do have some questions for Ms. Perry and Mr. McGee with respect to the properties. So I understand, at least from your notes, that you purchased the 1219 Fillmore and the 2728 West 13th in July of 2006, correct? And did you, prior to your purchase, did you contact the township to see if short-term rentals were permitted?
Under no, I did not, because I also wouldn't have contacted them for long-term either.
I understand, but you didn't contact them to confirm that short-term was permitted?
No, because there was other short-term in the area.
And with respect to 1003 Grant and 1103, you purchased those in, October of '21, correct? And did you, prior to the purchase, contact the township to confirm whether that use was permitted? Short-term rentals?
The answer is still the same.
I,
I didn't hear your answer, that's why I need them.
No.
Thank you.
Oh, plugged in. Might be able to adjust the podium one down to it. The podium one might be able to scroll over.
I can stand up. Thank you.
that works too. Usually I'm the only one over here.
I'll just speak into it really close when I have to talk.
Okay. I can do that. But with respect to all of the properties, is there any reason, and I know you went through this with the board, but is there any reason you couldn't utilize them as any of the uses that are permitted in those districts, as a single-family dwelling or as a warehouse or a garage, which, are permitted, or commercial use in terms of the C1 or C, is there any reason you can't do that other than you just don't want to?
I don't know what the regulations are to run a garage or business out of a house, like, that's there.
But I understand that, but with respect to the homes that are in the residential district, the 1003 Grant and
Oh,
the
those-
1103, is there any reason you couldn't use them as a single-family dwelling?
For renting for renting long-term, is that what you mean?
Yeah, just renting to people.
Any reason? Financial.
But there's nothing unique about the property.
Just financial.
So that's all I have for you right now. But with respect to the township's position, and I'll get into this with Mr. Puz, is that in May of 2022, the township did amend the zoning ordinance to specifically provide for where short-term rentals, or limited lodging as we call it, are permitted in the township. Prior to that amendment, they were not a permitted use within the township, anywhere within the township, despite the fact that people were operating in that fashion. The case that really applies to that is the Slice of Life case, which dealt with short-term rentals and long-term limited lodging and restricting that. And in that case, which Mr. Puz will discuss, but that established, and our ordinance mimicked the language that was in that case, that established if it wasn't provided for in an R1 district, it wasn't just permitted to be operating in that fashion. So even though long-term rentals or more than 30 days are permitted, short-term has never been permitted in the township as carte blanche until we adopted the 2022, where we restricted it to the limited lodging overlay district, the MU1 and the MU2 district, and the PI district, or PI Presque Isle Gateway. With respect to the hardship provisions, the applicants haven't satisfied those requirements. The property could still be used consistent with what the uses that are allowed in that district are, such as a single-family dwelling, which is what the property is. This board has previously heard another case earlier this year that related to a applicant who was seeking variance to have an Airbnb in an R1 district, and the board moved to deny that application to use the Airbnb in an R1 district because it wasn't, even though they were operating before the 2022 ordinance came into effect, it was still not a permitted use prior to 2022. And it's, was not permitted, and it still isn't permitted in the R1 district. And so that, the board has already denied that. the township made a policy decision of where to allow these, and they made the conscious decision not to allow them in the R1 district. And we are very much striving to not expand that, which is why there's precedent that's been set by this board that it's not permitted in the R1 district, absent a showing of a hardship under the variance standards, and that's not been met here. But with respect to that, I'm going to turn to Mr. Puz. And again, this is with respect just to the 1003 and the 1103 Grant Avenue. As I indicated earlier, with respect to the two that are in the C1 district, to the extent the board is willing to entertain that. Again, we don't feel the hardship's been met, but to the extent the board does, are agreeable, provided that they comply with the short-term rental ordinance requirements. If I may, now, Mr. Puz, could you please state your name for the record?
Matthew Puz Jr.
And are you familiar with the zoning applications for Mr. McGee and Ms. Perry with respect to 1003 and 1103 Grant Avenue?
Yes.
And where are those properties located? Like, what zoning district are they located in?
R1, single-family residential.
And in terms of that district, what are the uses that are permitted there? If you know off the top of your head, if not, I can provide you with a copy of the ordinance.
Generally, it's single-family residential, parks, schools, churches, places of worship, essential services, group residency, public recreation facilities, and then a special exception, bed and breakfast.
And I'm going to show you a document that I've marked as Exhibit B. Could you please identify this for me?
This looks like excerpts from the current zoning ordinance.
And you could please turn to what is marked as the bottom of, as page 45, so it's the third page in.
Okay.
Could you please identify section 145-15?
R1, single-family residential district.
And does subsection B identify all of the permitted uses in that district?
Permitted uses by right. Yes, and then the C would have the special exceptions permitted by right. Or, no, sorry, permitted special exception.
Certainly. And in looking at 145-115B, is limited lodging permitted?
No, it's also not permitted as an accessory use.
Now, the township ordinance, the current zoning ordinance was adopted in May of 2022, correct?
That is correct.
And this ordinance provides for limited lodging as a identified permitted use in certain areas, correct?
Correct.
And if you could flip to page 19, which is back one, what is this page?
That appears to be an excerpt from 145.11 definitions.
Okay. And if I could direct you to the definition of limited lodging
Okay.
overlay, or excuse me, limited lodging. Could you please read that?
Limited lodging, the rental of all or a portion of a dwelling unit in the following districts, MU1, MU2, and PI districts, or the limited lodging overlay.
And that does not, the definition of limited lodging does not specifically identify the R1 district, correct?
Correct.
And if you look below that, that is the definition of limited lodging overlay, correct?
Correct.
And I'm going to direct you to what I previously marked as Exhibit A. Did I give you a copy of that?
Thank you.
Could you please identify what this exhibit is?
This looks like the Mill Creek Township zoning map, specifically laid out to show limited lodging zoning districts.
Okay. And I'm going to show you a document that I'll mark as Exhibit C. Terribly marked. Can you identify this document?
This appears to be the current Mill Creek Township zoning map.
And does the, and I apologize, this copy, apparently the something's changed in my copier. But is the limited lodging overlay district identified in a hatched area?
Yes,
Okay. And that is limited generally to along West 8th?
West,
Route 20 or 5?
Westlake,
Westlake Road and near the peninsula, correct?
correct.
Now, I want to show you. Where did it go? Now, prior to the 2022 amendment, was limited lodging a permitted use within the township?
No,
And in the R1 district, not permitted.
correct.
And
And I apologize, I'm going to go back.
go, yep,
Just to state that there were some cottages down in the, I guess, this general area where along, it's currently hatched, that permitted, or that had short-term rentals. So I don't want to necessarily say there were none in the township, but at the time,
okay,
the zoning ordinance just does not provide for that use. At that time, correct.
certainly. And with respect to those rental cottages, were those identified as being permitted in a specific district?
Trying to think. Generally, again, they would be in this general area. I think that it was somewhere between R1 and R1, R1 single family, RC resort commercial, and I believe there was a C1 strip along the lake that may have had some cottages in it as well.
But generally speaking, R1 did not permit.
Correct. Oh, correct. It was, yeah, correct.
We did not permit short-term rentals.
Correct.
And I earlier discussed relative to the slice of life case. And the township's ordinance at the time, prior to the May 2022 amendment, was consistent with the slice of life case, correct?
Correct.
And can you speak to what the slice of life case provided for?
Yes. It was a case I went to, I believe, the Pennsylvania Supreme Court over limited lodging not being permitted in residential districts, and the court basically upheld the fact that limited lodging is a transient use, which doesn't necessarily, is not consistent with residential, a residential district. And in that case, the fact that the zoning ordinance did not permit that use anywhere was not relevant. It was just the purpose of the zoning ordinance was to protect the residential districts. And because of the transient nature, like I said, it was not a consistent use.
And turning back to Exhibit B, page 45, 145-15A, purpose. With the purpose of the R1 district to preserve the character of existing single-family neighborhoods. Is that what it currently says?
Yes.
And in preserving that, does anything in the permitted uses indicate a transient residential use?
The only one I could see would be the bed and breakfast inn.
But the use that the applicants are seeking is not bed and breakfast inn, correct?
Correct.
And when the township adopted the current zoning ordinance, was it a policy decision of the township to exclude short-term rentals and Airbnbs from the R1 district?
Yes, correct.
And in adopting the zoning ordinance, this was a very public process, correct?
Yes.
Went on for many years, maybe months?
Yes, I believe the first public meeting, public meeting regarding the zoning ordinance was, the reason why I remember, it was like 3 days before COVID shut everything down.
Okay.
So,
And then it was another 2 years before we adopted it.
correct.
And
About 3 days. I'm pulling from my memory.
And based on your review of the application and knowing the standards for the variance, is there anything unique physically about this property that would prevent it from being utilized in accordance with the permitted uses in the zoning ordinance?
Not that I'm aware of.
Okay. That's all I have for you now, Mr. Puz.
All right.
That's all I have, gentlemen, at this point in time.
Okay.
Again, our position is, with respect to the first two, we're willing to concede in that regard. But the 1003 and 1103 grant were single-family dwellings prior to their purchase in 2021. And the use as a short-term rental was not permitted in 2021. And actually, before, yeah, I think that's all for right now. Was not a permitted use in 2021, wasn't a permitted use in that district after May of 2022, except for the specific areas identified on the township's map, and in the MU1 and the MU2 district, in the PI district. So,
Okay.
Would respectfully request with respect to those properties that the variance be denied, as they've not met the standards for a hardship, because they could be used consistent with the zoning ordinance.
Okay. Like to,
Okay, I didn't get the one packet that she was
I put it
referring to.
right here.
Oh, I saw you hand it to them, and I didn't get it handed to me, sorry. So the short term, Matt, did point out the bed and breakfast, which is a short term, so that is an exception. And he also pointed out that the rules for no short term said, you can't have short term, but there was, special exceptions. So there is currently, and there was exceptions made for short term as such, the bread and breakfast, and as
Bed and
such,
breakfast is a separate use.
and as such, the cottages, because I know Pittsburgh people, some of the houses we had were cottages that they would rent out. So there were short-term uses, and also the MU and the ones that were approved, before they were approved, I'm pretty sure they were R1, they were residential areas. So it's not like they can't approve an R1 strictly, I'm not here arguing that we're in an R1 and we're not supposed to have a rental. I'm not arguing that. I'm asking for a variance because I didn't know it before, and because other R1s are permitted to have the short-term rentals. So that's simply my defense. I'm not saying we're not in an R1, and I'm not saying I didn't know that. I clearly know that. I'm here for a variance because of that. And other R1s were approved for it. So that's really my only plea in defense of, her pointing out that it was R1, it was never permitted. The omission of, it wasn't really said whether it was or not is really not a viable, reasonable expectation for a resident to assume that nothing's allowed. But the fact that there were cottages in R1 zones that did have short-term housing, and that the bed and breakfast is an exception, and I know they're different, and I know that one was approved, and I know that some of them can continue to be approved, but the fact that they're short-term doesn't jeopardize the neighborhood, and neither does my short-term. And that's kind of like what my defense is that they approved certain R1 areas. I think that they could expand it, and maybe it's not in the future for a long time, but I just think that, in the time being, I think that I've met the hardships, and our definitions of hardships are different, but I believe that when you explain hardship, it shouldn't limit it to what is listed as a hardship. We put a lot of time and energy, and we are Erieites, longtime Erieites, and we want to, make the community better and provide a wonderful place for people to visit. We're not trying to be deceitful and be slumlords. We're trying to improve our community. So denying it is something that, you know, it is what it is, but I still wanted to defend myself properly today.
Okay.
With respect to anything that's purportedly a cottage in the R1 district, absent anything indicating that it is or isn't, I can't, just because she says that there are some cottages in the R1 district that have been approved, she's not provided any evidence that there is anything that's been approved. I understand Mr. Puz has testified that there were cottages, but there was a permitted use in certain areas for rental cottages under the RC district. This is, again, the R1 district. Again, there's also people that utilize properties that is not consistent with the zoning ordinance, and absent there being notice, we're not out there hunting for people.
Okay.
So just because someone's using it as such does not necessarily mean that it has been grandfathered or permitted as such.
Okay.
In the comment regarding bed and breakfast, do you want to speak on that?
Certainly. Yes, the bed and breakfast is provided for as a special exception in the R1 district, and by the nature of it being a special exception, it is a permitted use, provided that they meet those criteria. So we're not making some specific exception for them. It is a permitted use. And there are certain criteria. Again, they're not seeking to do a bed and breakfast here because that requires the owner to live at the property and provide certain meals and options to the guests. And it is not a short-term rental. So,
Okay. All right, well, if there's anyone in the audience who'd like to come up and speak on this, just one at a time, come up, please state your name and address.
Nancy Faye Greiger. I live at 1109 Shank Avenue,
And what is the,
over.
so it's one block over, okay?
Yes. But, you know, it's a residential area, and we would like to keep it that way. Now, they purchased them, knew they were residential area. So they should have sought out more information before they invested all that money in there. Also, I brought a list that are probably already zoned for different places for multifamily. There's one in Edinburgh, 17 beds and 8 baths. That would be a good investment. There's one on West 8th Street, 25 beds, 7 baths. There's one
Okay,
in Court.
I don't want to cut you off from what I just want to get
But-
your feedback on it. As far as that goes, those are multifamily, and I
Right.
understand you're trying to provide some
Right.
other information, but
See the investment.
I wanted to
They
get
wanna
your,
invest, no
so
problem.
you are an adjoining property owner and you are opposed to this being granted, is that
Correct.
what you're stating?
We want to keep it as an
Okay.
R1.
Okay, thank you.
Thank you.
Do I get to say anything back?
You can say something.
I understand your concern, but most of the short-term and the Airbnbs are all in residential areas. So a short-term rental, you know, just to make it a little bit more understanding, is it's not, you know, it's really not any different than a long-term, that's all. And I feel bad that you are, you know, distraught over it, but the investment is for Erie, not for any other areas. Thank you.
Yes, briefly.
Because for the cottages that you guys are talking about, a lot of them are in Kelso. Some of them are R1, some of them are rental, because I used to work for the lady who owned all the rentals.
I have 7 other houses in a residential area, that's all I'm saying.
Yeah.
Okay.
But, you know, they're out there, and Kelso is for sale.
Yeah, I know.
Okay.
I just wanted to make sure that you knew that I didn't oppose what you're saying, just that it was.
Is there anyone else?
Robert Sormer, 1019 Shank. I'm a couple houses up from Nancy, right, block over from Grant. I'm just want to express that I'm opposed to this also.
Okay.
It's a family neighborhood. I've lived here for 40 years. All my kids grew up here, played with all the other kids in the neighborhood. I just don't feel it belongs in our neighborhood. I'm sorry that it's going to hurt you financially, but I believe that if you were to approve something like this, you'd be opening up a can of worms for many more properties to try to follow suit. So,
Okay.
Just to confirm, the opposition, is that to all of the properties or just the two?
mainly on Grant. Now, if there's ones that are already, like the one where by the junkyard or whatever, way I look at it, you buy a house by a junkyard or whatever, you get it cheap because it's not worth very much. That's your problem. If I buy a rental, I pay cash. I don't worry about how much I have in it, and I don't expect to make money off of it right away. But when you buy,
Okay.
where that house is, no matter what, it's kind of, you ever listen to Dave Ramsey? I mean, he's the perfect guy. Don't buy properties without paying cash. But anyways, I'm just want to let you know that I'm totally opposed to
Okay.
it, so.
Just a rebuttal on his family being raised here, and it's a family neighborhood. Honestly, everybody that rents on those Grant Streets are families. They're usually two families with children. We have a little playhouse in there for them. So these are families coming to Erie to make memories, and they go to the peninsula, and they're repeat customers, and they're here for vacation. They're not here to destroy our neighborhood. They're here to enjoy what Erie has to offer and be a family in a family neighborhood and not in a hotel.
Hi, I'm Lori Niemans, and I live on Schenck as well, right close to these other people.
What's your address?
1101
Thank you.
Schenck. 30-year resident on Schenck,
Okay.
lifelong Erie resident. My concerns, I'm opposed.
Okay.
I'm opposed. It's R1, it should stay R1. You open up a can of worms once you change zoning, and it's a permanent change. Unless somebody does the same thing here, I am opposed to
Okay.
changing the zoning. I get concerned when you see that there are so many people that are trying to find houses in good family neighborhoods, in good school districts, to know that this is transient type of living. I recognize that it's a great industry for a lot of people, and I am sorry for your challenges too. But at the same time, I didn't realize that there were things going on like that. So I probably would have been opposed if I knew about it. So you must have been doing a good job, but it still doesn't negate the concern for changing the zoning at all.
Okay.
And the need for good family homes in that area, in that school district. There's been a major demand for housing in that area, and they're snapped up before they even get on the market. And I know that from personal experience, so. Yeah,
Okay.
and I don't know what the VRBO regulations are or the expectations are. Who knows whether they're going to be around in the next 2 years. It's not a comfort to know that they have expectations of the owners either. So will be anxious to see where the other properties are, and I will pursue that a little bit more. This is all new to me, and I appreciate the time to talk.
Thank you.
Thank you.
Is there anyone else?
Hi, Christine Greiger, 1109 Schenck Avenue, and I mainly have some questions because I've been taking notes throughout this. When you say that it will up the properties that already exist, do you mean it will technically have problems with people that already own like the houses and live there and everything when it comes to taxes?
No, it won't have any impact. It's just on a resale value. So if you were gonna sell your house to somebody and it was approved for short term, you could sell it for more because they know they can make more money.
Yeah, but what about the property taxes when it comes
Nothing
to?
changes.
No, great.
Nothing
Did it ever
changes for the
change?
property tax fees at this point, because there's mixed housing there. It only impacts the.
Yes, and currently this format is not in the zone, but even if yours is allowed, what is ever preventing any of the other people to buying up property and then doing the same thing? Then you have no longer residential areas, but more people selling them, renting them out to the point where you're looking at more of a rental area than a neighborhood when it comes to near, it could be anywhere when people could do this.
So based on your comments, you're opposed to the variance?
Yes, but I will admit you've been doing it for 9 years. Rather it was legal or not, considering, I don't even know if you knew about the change or anything beforehand.
Well, I mean.
Because it seems out of nowhere.
I mean, and also, I just want to remind everybody too, that the houses that are in these blue areas were residential houses at one point, because I live in a residential neighborhood, and the whole entire neighborhood is in this blue. So every house in there has the opportunity to be a short term. So it could be for you to make money if you had one, or for anybody that owns those houses in there. So like your residential area shouldn't be more special than my residential area that I live in. There was 2 residential areas, one got approved and one didn't. I don't see why there should be a favoritism of it.
And then you bring in the tourism. And this kind of has to do with what they did around the peninsula, because there was a hotel there, and no one decided to ever fix it up and just do that for the tourism. Like, yes, we might get tourists, but if you check Erie's scale, we've been going down in tourism, according to the internet. But then again, I don't really know that much, but my dad knows that much, and he says Erie is slowly going downhill because of one thing. We love tearing down what is already there, that we could be using and rebuilding and everything else. And yes, you do have property that could be used, but it could also be used for other things maybe in the long run than just renting it out for like the tourism kind of thing. Because you did mention that you could end up selling them on the market, but you never know when they're going to do that or not. And you don't even know at the moment if you'll get zoning's full approval with the flooring or anything else. So if anything else, I am wondering one thing. What will you plan to do if zoning doesn't allow it?
Well, my answer to that is we could be long-term, we might have to apply for, Section 8 housing for people so that we can get guaranteed payment, because with long-terms, it's hard sometimes to collect rent, where Section 8 is paid by the state, so we would get guaranteed money, so that's a possibility.
And that would be it. Thank you.
Okay.
Thank you.
Is there anyone else?
Hello. I'm Tim Peterson, Senior, and I own commercial property at 1225 Fillmore Ave.
Okay.
Property she talked about collapsing last November, the roof caved in. Half of the property, or a quarter of the property, is still there. I plan to remodel that, and I'm actually going to fence in the other part of the lot. It's a commercial lot, and I have a landscaping company. We're actually going to park more cars there and trucks, and I'm right beside and they're right behind me and
Okay.
right to the north of me. So east and north, their house sits. So with the repo lot back, behind the other side of the house, I support, I think, they've had these Airbnbs for a while and a long time, and I support the rezoning.
Thank you.
Okay, thank you. Anyone else?
Hi, Dan Ball, 1004 Montpelier, next door to the 103 or 1003 Grant. Never had any problems. I guess I support them because, I know they put a lot into those houses, and never had any issues with renters, no noise or whatever. And it is nice seeing families come and go, enjoying our area. But most of why I come here was just to support her and Jason also, and I've never been to one of these meetings, so I wanted to see what it was about. So got that done.
Good.
Checked that off the box. But I guess I was confused too by your map, why they have zoning stretched thin in certain areas and other. I mean, I'm not part of that, so
Sure,
that's
so
something for
we
the-
here for variances, right? We
Yeah.
don't.
that's what I
write it.
understand. This is all for a variance,
Out of
but
our-
I'm a little disturbed on how they come up with some of their things anyhow, but that's for another forum, I guess. But, so anyhow, appreciate you letting me come up and
Okay, thanks. Okay, being that we've heard from everyone, we're going to take some time to recess and discuss these. We'll be back shortly. Okay, let the record show that we reconvened at 7:54-ish. On appeal number 25-15 for property at 1219 Fillmore Avenue, do I have a motion?
I will make a motion on 2515 as well as 2516 that we would approve contingent on meeting the requirements of 145-61 for limited lodging.
I will second. Is all in favor?
Aye.
Aye, so moved. Do I have a motion on number 25-17 for property located at 1003 Grant Avenue?
I'll make a motion on 2517 as well as 2518 that we deny the variance request.
I will second. All in favor of denial? Aye.
Aye.
None opposed, so moved. Do I have a motion for adjournment?
I will make a motion.
I will second, so moved.